What's up, guys? Colton Richardson here, personal injury attorney and former prosecutor. We've got Alex Murdaugh trial still going on, day 18. It has been a long trial, and there's some crazy things that happened today, and actually only two witnesses. I don't think they finished that second witness. So very slow, long day. And we're actually going to start off with, there's some arguments on trying to keep some evidence out. And so we're going to watch that to start off. And then there is a twist at the end, which is pretty crazy. So let's jump right in and start watching it.
May now be seated.
Whoa.
Good morning.
Let's refresh that. There we go.
May now be seated.
No, I guess we're not. Guess we got to keep it at that. I can't go full screen. Oh well. There we go.
May now be seated. Good morning. Ready. Who's first?
I'm happy to go first. Obviously, Your Honor, since we filed a memo and we have not added to it, I'd be more than happy for the Attorney General to go first.
Yes, sir.
So let's slow it down a little bit so we can understand what's being said. So what's going on is they filed a memo for the court to address a certain issue, and the defense filed it, and so they have the first argument, the burden, if you say.
Your Honor, and I sent a memo early this morning. Hopefully you've had a chance to see that. A lot of it reiterates what we had previously filed in our prior motions. And again, as it relates to this particular evidence, as I argued yesterday, consciousness of guilt is a very recognized class of evidence as admissible evidence of.
So what they're arguing right here is Alex Murdaugh actually, what they're saying is he staged a suicide, that he faked a suicide, and it was actually an attempt because it did not work or follow through. And so obviously he's still here. And so it was actually just a attempt at suicide. So they want to introduce this evidence in the trial. And like the prosecution just said, he wants to admit it for purposes of showing his guilt, showing that he's guilty. He feels bad. He feels sorry. So he's going to take his own life. So I want to clear that up before we get started, because they didn't really introduce what evidence they're arguing about.
Of motive and identity in South Carolina courts. Obviously, that we've cited a number of cases in more classic senses of consciousness of guilt evidence, such as witness intimidation, flight, but any sort of evasive action, any sort of action to evade detection or throw off the scent has been admissible in our courts. Your Honor, I see the clerk from Barnwell here, and I had a murder case in front of her not too long ago, or it's been a while, but in any event, in that particular case, the defendant had actually found in his car was a voodoo root that said, had on there, protect me from murder charges, save me, judge, early, protect me from murder charges. And ultimately that was admitted and in an unpublished opinion affirmed as evidence of consciousness of guilt and evasive conduct because of what it meant to the defendant. And so I just point that out as an example as to how expansive that can be. When we look at this case, and again, one thing about this case, Your Honor, is it's intricate and complex on a scale that I think none of us have ever seen. And so we have to look at it within that vein and in that context. And what we have here, Your Honor, and why this is relevant evidence of consciousness of guilt, it really doesn't matter what exactly happened on the side of the road, because that's not the focus of what the state is seeking to do. What the state is seeking to do, and what we believe is relevant and admissible under these rules, is to show what the defendant said about it and the fact that that was not true. And what he
So sometimes when you're making an argument like this to the court to get evidence admitted, sometimes you just got to show your hand as to the reason why you're using it, and so that's what he's having to do right here.
Said about it, of course, was that he was on the side of the road. He had a flat tire, and with a car that has run flats, that he was changing the tire, and that a nice-looking, nice man stopped, offering help, and then all of a sudden he was shot in the back of the head. And obviously, the initial reaction we've heard from Ms. Proctor, we've heard and can hear from other witnesses, and the initial reaction was that, oh my gosh, the real killers are back, the bad guys are back, they've now targeted Alec. And the other thing that's crucial about this that connects it all together is not only does he make that claim, that statement about being targeted by an unknown assailant, as things were heating up on him in this investigation, that then causes people to immediately assume that he's been targeted and it has nothing, in no way could he be responsible for Moselle. But we also have to look at the symmetry of this particular event with what happened on June the 7th. And on June the 7th, as we know, and Your Honor's heard extensive testimony, both in camera and in this trial, he is confronted about the fares fees that morning. There's all kinds of circumstances that have been put into evidence that are moving as to a perfect storm arriving on that day. And of course, what happens that night? Maggie and Paul are murdered, community rallies, everything changes. We have the same thing happening on September 3rd and September 4th, because finally, despite his best efforts, the law firm has become privy and wise to what's been going on with his years of embezzlement and theft. They confront him. But more importantly, if we go back to those fares fees, which are very crucial and temporally connected to everything that happened on June 7th, is the fact that you've heard testimony from Chris Wilson that he is calling Mr. Murdaugh, trying to get to meet with him because he wants to know what's up. He particularly wants to know what about the $192,000 of those fares fees that he covered for Mr. Murdaugh. And they have that confrontation on the porch of Alameda that afternoon, or early, right before noon, as was testified to. And what happens? Yet again, within a couple of hours, the side of the road happens, and everyone is rushing to Alec Murdaugh's aid again. The fact that he had just been exposed for embezzlement is quickly forgotten about. And of course, everybody's assuming, oh my gosh, it must be the real bad guys, when in fact, it was him all along. And so that is extremely relevant evidence. And it's also been, just to add into the calculus, Your Honor, is we do have the concept of what's been opened the door, what issues have been joined by the defense and put up here. And of course, that's how this issue all arose yesterday with the testimony of Miss Marianne Proctor. So we think it's very admissible as clear consciousness of guilt evidence. It's admissible under 404. I've also argued, without getting into great detail, when we talk about that symmetry, we talk about common scheme or plan. And again, this isn't the kind of common scheme or plan that is typical, but we have to look at this case through a lens that recognizes just the intricacies and the complexity of a set of circumstances like we've never seen. And so all those legal theories, Your Honor, we would assert justify admission of this evidence. I will also say that this, express this to the defense, that it's the state's intent to really quickly move from point A to point B. We are not here to try to litigate what happened on the side of the road in its entirety. I believe that the testimony about this could be done in just over an hour, and that includes playing the recorded statement. There's a number of recorded statements, not trying to play all of those. It would just be simply having the agent come in, relate the story that Alec Murdaugh told to 911 and told to law enforcement, that initial story about the unknown assailant, the fact that the investigation continued and additional information came to light that conflicted with that, and that he was eventually confronted with that. And then there's a recorded statement at the end in which he admits that, in fact, what he had told law enforcement was a lie. And so trying it would be a very focused presentation to just get from point A to point B for purposes of this trial and the relevance that it has to this trial. So for those reasons, Your Honor, we would assert that limited presentation is admissible for those purposes.
No, he says it takes an hour. Really? It probably takes a couple hours at least. But one of the other things he said is he's not intending to try this case within this case, which we've already really tried a few other cases within this case, including his financial crimes, because the state is alleging that that was part of his motive to cover up those crimes, and to evade those crimes. So again, he's trying to pull in a whole nother situation and evidence of trying a whole nother case within this case. So that's pretty interesting. A lot of times the judge doesn't allow another case to be tried within one case, but it is acceptable in some situations. And as you figure out under the law, there are lots of exceptions.
Court, Your Honor.
Yes, sir.
The state, and we agree that State versus Cartwright would be applicable to this situation. And it has 4 criteria about a suicide. They seem to think that the unmistakable nexus exists by clear and convincing evidence linking the suicide attempt to a guilty conscience about the murder. The facts are that he was confronted by the law firm on Friday, fired on Friday, and then persuades, I don't know much persuasion was needed, Eddie Smith to shoot him in the head, thinking that it would get his son, Buster Murdaugh, $12 million in insurance money that would otherwise be excluded by the suicide exemption in his insurance policy. So
with that, there are exceptions in suicide. Exceptions in life insurance cases that if one does commit suicide, then the life insurance policy can be terminated. There are some laws, like for example, in Oklahoma, a insurer can only terminate a contract because of suicide within the first 2 years, I think is the time frame. And so what they're saying is, what the state's trying to do is show that these statements made by Alex Murdaugh is showing guilt of the murders of his family. But what the state is saying is this is just showing guilt for a different situation, the financial crime situation. So
all this is linked to is the financial crimes, not the murder. We're here trying to murder. And yet all the evidence, not all, but a significant amount of the evidence we've heard over the last 3.5 weeks has been about the financial crimes. This is guilty knowledge of the financial crimes, not the murder. And this under 404, 403 analysis under Cartwright would not be admissible. I'd further say this: if he's looking for a common scheme, that is, that when he's about to be found out or he's being found out, he would have killed Buster based on.
Yeah, so under the federal rules of evidence, and sounds like South Carolina rules of evidence, you can admit situations where similar conduct. So there's what the state's saying is he tried to get out of one situation by killing himself, and now he's trying to get out of this situation by killing others.
Based on his theory, to distract. This isn't a distraction. This is an end. And clearly, you haven't heard the taped interview that he initiated from Detox in Atlanta, in which he explained he was killing himself to get this money for Buster because his financial crimes had been found out. This is 3 months.
So if the judge does allow that evidence to come in, if I was a defense, I would definitely bring that other statement in, that of the reason why Alex Murdaugh was staging that suicide.
After the murder, this is in September. It's not connected by time. It's not temporal under the 404, 403 analysis.
Those are good points.
And certainly it's not evidence of guilty knowledge about, his own statement would indicate it has nothing to do with the murder. It's only about the financial crimes. And he contacted Sweat, and on that recording, myself, Mr. Griffin, and Mr. Murdaugh from Detox. He finally had detoxed and wasn't on drugs anymore. And he has a great detailed statement about Eddie Smith buying the drugs for him over a number of years, millions of dollars worth, and how Eddie didn't hesitate to shoot him in the head on the side of the road. I don't know how that is relevant. Now, maybe the drug piece is, but they've got statements from Eddie Smith about what drugs he bought and what he did with those. So we would oppose going forward on any roadside shooting evidence. We think the prejudicial far outweighs the probative, and we'd ask Your Honor to not allow them to do that.
Yes, sir.
Your Honor, very quickly, I do want to distinguish again between what Mr. Harpootlian keeps wanting to argue about, and that's the prospect of there being some sort of suicide on the side of the road. Again, the state's real focus is not exactly on what happened on the side of the road. What's important, and this is, I think, different from a typical court rape such situation, is what the defendant said about it. And the fact that he immediately tells this lie about him being targeted by an unknown assailant. And that is what directly connects it back to Moselle, and that's immediately what everybody assumed. The first thing that jumped in their mind is that connection back to Moselle. That connection and the next is unmistakable. So it's not as much about a traditional type of Cartwright analysis. That's not what I'm arguing here. What I'm arguing here is his explanation for what happened and the fact that that ultimately was not true. And that nexus, I believe, is very clear. I think the other one would be clear too, but that former nexus is the stronger one, and that is the focus of what the state is trying to offer here today.
Your Honor, just briefly, this is character evidence, which is precluded under the only exception to 404, 403 Your Honor's allowed in is motive. Why did he do it? It's just incredible because if you put this up, you're going to hear from one of the SLED agents when he woke up in the hospital and his skull had been fractured. He had a brain bleed. This is when he concocted that story. I mean, he expected never to wake up. So, this was a scheme to draw. No, if there was a scheme, it was created after Eddie Smith meant to shoot him. Actually, if he'd been a millimeter to the left, his brains would have been blown out. He just missed, but knocked him out, fractured his skull. That's all I have.
All right,
So before the state responds, the federal rule of evidence, and I assume the South Carolina one's similar because they named it after the same number. Usually, character evidence is not admissible except for limited situations.
Are not the facts. He's telling that story at the scene to people who show up. He's out of the gate. That's what he's saying, that he was attacked by an unknown assailant. There's an ambulance video where the deputy comes in, and that's exactly the story he tells. This is not.
I would concede he's correct. Once he realizes he's still alive, he tells that story. But obviously, he didn't intend to be still alive. In other words, it's not a scheme that was concocted at any point. The scheme, if it's a scheme, was concocted after he realized he wasn't dead.
Well, the financial evidence was allowed on the issue of motive. This evidence, I find, goes beyond motive, or is not evidence of motive, but more toward common scheme or plan. It does not survive the logical relevancy test, and it
So real fast, what he means by survive the relevancy test is everything that's admitted at trial has to be relevant on some point. You can't just admit evidence that he went to the grocery store 10 years before that. Obviously, that's not relevant, so it's not admissible. So that's what the judge is talking about there.
goes more towards showing the propensity to commit violent acts, which would cause it not to survive the 403 analysis.
Which is true.
I believe that to allow this evidence is a bridge too far, going down this path of allowing essentially any and all evidence in. We have guardrails. The court is to place guardrails to keep things within a reasonable realm. And I believe this, as I stated, will be a bridge too far. It does not meet the logical relevancy test. I agree with the defense that it would be admissible perhaps if the trial was a trial on the financial theft issues, but not on the murder. So I grant the motion to exclude this evidence at this time. Of course, as we have seen, things change. And who knows?
So he granted the motion to exclude this evidence from the trial, but he says for now at this point because it could be relevant. And the plot twist is, I haven't watched it, but I read about it. He actually changes his mind on this issue and is going to allow this evidence into the trial, which one will make the trial longer, but the state says it'll only take an hour, which I think they're just blowing smoke on that situation. But he does change his mind. He flips the script on this, and his reasoning of what I read is that this defense opened the door to this evidence. So I don't know what line of questionings that the defense did, but they opened the door. And what that means is they asked questions along the lines of the situation, or if the state tries to admit, or if the defense tries to admit evidence of, say, Alex's peaceful behavior, then the defense opens the door for the state to admit evidence of Alex's violent behavior. So that's what the judge did, is he says that throughout this day, the defense opened the door to this evidence that can be admitted after the questioning from today, which is very interesting. So
Understood, Your Honor.
that's why I said at this
All
time,
right.
a lot of things change at trial.
Did we tell the jurors 10 or 10:30?
I think we said 10:30, Your Honor.
10:30.
I said 10, Mr. Waters said 10:30. So if there's any acrimony here, please focus it where it belongs.
And psychotic goldfish, how do you miss from 4 feet away, though? The first time I went shooting, I hit my target from much further away. And yeah, that is a great question. It's a shotgun. And so it's not too difficult to miss. So you're absolutely right. That is a great question. Oops. Let's see.
Has been excluded and is not
Nope.
being considered. Otherwise, it has the ability to confuse the jury, and they're going to be feeling like, did we not get?
Let's see,
the full
when
case,
do they
or
come
did we
back?
not get everything?
Motive.
Nope.
This day number 18, state's case. I'll call you next witness.
And so after the state rests, I don't know the exact law in South Carolina, but once the state rests, you can ask the judge for a directed verdict, or they have different sayings sometimes, but that's asking the defense asks the judge to say, hey, they didn't present evidence of any of these crimes. The state didn't meet their elements. So please dismiss this case. It's very rare that a judge actually does that, because a lot of times it's a fact question. It's a question of fact, whether something happened or not, or whether certain evidence was met or not. And so the judge will usually deny those requests for directed verdict because he wants to leave it up to a jury.
Please, the court. State of South Carolina, we call Special Agent David Owen to the stand.
David Owens was on there for a very long time.
Thank you. Raise your hand. Do you swear or affirm that any testimony you give David be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I thought she was Detective
Take the
Owens.
full name for the record, spell your last name, and move that mic or chair to where they can hear you best. Okay. Mr.
Special
Dodd.
Agent
Hold on a second
David.
for me. Thank you. No problem.
My name is David Owen, O-W-E-N.
Good morning.
Good morning, sir.
Would you please tell the ladies and gentlemen about Special Agent David Owen?
Yes, sir.
Your background,
Yes, sir.
where you're from, and your education and training that led you into law enforcement. Please.
I was born and raised in Orangeburg, South Carolina. Graduated from Orangeburg High School, graduated from Limestone College with a bachelor's in criminal justice. Began my law enforcement career in Orangeburg in 1996. Moved to Charleston in 1999, where I have been since, and began my career with SLED South Carolina Law Enforcement Division in 2015.
So they always ask these up.
Have you worked different areas in SLED?
No, sir. My entire time in SLED has been with the Low Country region, which encompasses 12 counties. We do general investigations, assisting the 12 counties with whatever they request. Anything from public corruption, officer-involved incidents, violent crimes, property crimes.
And when you say assist local counties, I know what that means, but what does it mean in your world?
SLED is an assisting agency. I like to explain it as if you call 911 for an emergency, you're going to receive local assistance from the police department or the sheriff's office. SLED's not necessarily going to show up unless requested from the local police chief or the sheriff.
And is that done regularly, and has it been done regularly in your career where you've been called upon to assist local agencies?
Yes, it is.
That was a good explanation.
And just as an aside, as we've gotten to know each other recently, you've got some relatives in Anderson that I knew in high school, didn't you?
Yes, sir.
Small world.
Small world.
Yeah.
Let's go straight to June 7th, Special Agent. Were you on call June 7th of 2021?
Yes, sir, I was.
And how did you get specifically, how'd you get the call?
I received a call approximately 10:30 that night. I was in bed trying to go to sleep, and phone rang, and I was told that I needed to respond to 4147 Moselle Road in Arlington, Colleton County. There had been the discovery of 2 deceased persons at that location.
And how long did it take you to get to 4147 Moselle?
I arrived on scene approximately midnight.
I'm sure it's been said, but it's 4147 Moselle in Colleton County.
Yes, sir, it is.
Now, when you arrived, tell these ladies and gentlemen what you observed.
When I arrived, there was multiple law enforcement and rescue personnel on scene. Of course, I had to find a place to park out of the roadway. Made my way up to the scene. My normal course of business, or the procedure, being that we were requesting agency, I locate the agency that requested us, this being Colleton County, and speak with the supervisors or detectives on scene and say, hey, what's going on? What have you learned so far? What do you need from us? At that time, one of my supervisors, my captain, Ryan Neal, was on scene, and he was already talking with Colleton. So I was briefed on the situation, what was discovered and what had been done so far.
And did you have a liaison, somebody that you requested or told to work with on the scene that night?
Yes, sir. Originally, as I stated, we were called in to assist. So I was paired up with Detective Laura Rutland with the Colleton County Sheriff's Office, and I was to assist her in any fashion that she needed.
And again, was that unusual for a local agency to call you in to help with the crime scene?
No, sir. It happens very frequently.
And when you got with Ms. Rutland, tell the folks when you were first at the scene, did you make observations in your mind of the scene itself?
Yes, sir. I observed the scene, kind of figuring out what's going on. Started walking the outside of the scene, trying to understand the lay of the land, figuring out if anybody had been interviewed already, what methods or avenues were being taken to try to figure out what's going on, secure the area, and whatnot.
And did you see the bodies and we're all of Paul and Maggie?
Yes, sir. I was standing outside the crime scene tape, and what I know now to be Paul Murdaugh and Maggie Murdaugh, I knew that there was a white male and a white female, but they were covered up with a sheet. I was not able to see them, but I saw where they were.
Did you make any other observations of the actual crime scene there itself then?
Other than the placards or evidence placards that Colleton County had put out to protect evidence upon their initial arrival, I didn't go into the scene. Our crime scene unit had not arrived yet. I have a background in crime scene, so I knew not to go in and disturb anything until it was documented properly. I was aware that Colleton County had already documented or located and marked some evidence for protection purposes. So I just walked around the crime scene tape. I knew that there were dog kennels on the left. There was a big shed on the right with a large field behind it with another shed. And there were several people and several cars back behind when I called back behind the crime scene from where I was standing.
And at this point, had you seen the defendant, Alex Murdaugh?
I was told that he was with the group of people behind, which was told to me to be some family members and some of his law partners.
And I guess you became, at this point, were you the chief investigating officer?
I don't recall how long, within maybe 30 minutes or so, my supervisors pulled me aside and said, you know, hey, we're actually going to be the lead on this. So my Detective Rutland and my roles kind of reversed, and I became the lead investigator, and she was my assistant.
Y'all still working together?
We were still working together, yes.
Had you ever worked with her before?
No, sir. I knew her, but I had never worked with her before.
Did you think it was important to talk to Alex Murdaugh?
I did.
Leading
And
question.
can you tell the jury specifically how that came about?
Well, I was told that he arrived on scene and discovered his wife and son, and that he had made the 911 call. Being that it was his wife and son, and he found the bodies and made the 911 call, it was paramount that I talked to him. You know, what was his observations? What's going on in his life? What's going on in Maggie and Paul's life, to try to figure out what happened. I still didn't know if it was. Let me back up just a minute. Going into a death scene investigation, homicide investigators are taught to treat every scene as a homicide until determined otherwise. And that encompasses suicide, natural, accidental, or homicide or unexplained. So automatically I was treating it as a homicide, and I didn't know if it was or not. So it was paramount that I speak with Alex Murdaugh to try to determine what he saw, what he experienced, what's going on in their lives, to kind of help guide my investigation as it progressed.
And had the weather started to change about that time?
It had been changing and continued to change. It was raining intermittently as I was coming into Walterboro from Charleston. It would stop raining, it would mist rain, it would heavy rain. So, you know, the weather was also a concern that night, especially being an outside scene.
And that leads into my next question. Where did you request and where did you take the first statement from Alex Murdaugh?
When I met Alex Murdaugh, there was really nowhere else to interview him except the privacy of my patrol car, which was a Dodge Durango.
We all seen the video, and I'm not going to play it again. The jury will have that. But can you tell us where is your car?
Yes, sir.
So we've seen the video. Where was the camera?
It was a body camera. It's not a fixed.
So they admitted that evidence through another witness. And like I had mentioned before in the other videos, the best goal for either the state or the defense is to get 1 or 2 points from each witness. Don't overload each witness, because then you'll bog down the jury, confuse them, and everything.
Fixed in-car camera like in most active patrol cars, but I clipped it to my visor right above me and just angled it towards Mr. Murdaugh.
Is that your practice to video when you're potential suspects, or do you video?
I video any witness or audio record any witness that I am able to do.
So you're in your driver's seat.
Yes, sir.
Where was the defendant, Mr. Murdaugh?
Mr. Murdaugh was sitting to my right in the front passenger seat.
And behind him?
Behind him was Detective Rutland.
Okay, and to her left, if you will.
To her left and behind me was Danny Henderson. At that time, I knew he was an attorney, but I didn't realize his involvement other than an attorney. Later on, I found out that he was a partner and Alex Murdaugh's personal attorney.
And how did he get in the car?
Who got in the car?
I say, how did
Mr. Murdaugh?
No, Danny get in the car?
I mean, it's common if there's an attorney present that wants to be involved in the interview or sit on the interview. I allow them to sit in on the interview. It's not an issue for me.
You said
Allow them. You have to let them in if whoever you're questioning wants the lawyer there. So, and this goes on for quite a while. And even in the afternoon, they play another interview. So this detective actually got to interview Alex Murdaugh a couple of times. And one of the things that happened in that is Fleming, who is one of Murdaugh's attorneys, who's also indicted, demanded Owen, so this detective that's questioning Alex, to say if he's asking Murdaugh questions to further the investigation or if he's asking Murdaugh questions because Murdaugh is a suspect. And Special Agent Owen says he's trying to further the investigation. He's trying to eliminate Alex as a suspect because he's obligated to treat Alex as a suspect because he was the first on the scene. And so Fleming, who was acting as Murdaugh's attorney in this interview that they played in the afternoon, actually asked those questions, and Special Agent Owen was like, I'm obligated to treat him as a suspect because he was there. So let me know what you think about that. But that is about all I have time for today. If you drop some comments below in the video, I'll try to answer them on the next live that I do, either tomorrow or Friday. And wanted to say thank you guys for joining. And it's always a pleasure to watch these and comment on them and answer any questions. So thanks, and I will see you next time.